Lords. I was making very short reply points on VISA Inc. and I'm about to finish. I have two further short points to make about it, and they are very short. One of my learned friends' points of distinction between the VISA Inc. case and a situation in which you have an airport charging airlines. My learned friend said another point of distinction is that with an airline or airport, people have a choice and they can go elsewhere if the prices get too high. With respect, that's to some extent to miss the point. If the prices get too high, then there is a different competition concern to the one that you're dealing with here. And it may be an abuse of dominant position, and indeed with the airports it might be an abuse of dominant position. But it's not the concern that the Supreme Court was concerned with here. Another point in relation to that particular response to our case is this. We're in an IFR world, because VISA Inc. happens in 2016, the IFR coming in December 2015. So the prices can't get too high, because they are in any event capped. Now, again, so it's not the UIFM argument, it's a separate argument. Even if we're wrong about UIFM, you still have the IFRs in the world. Those prices can't get too high. I think the last point I wanted to make, subject to your lordships, is this. My learned friend at the end of her submissions on this part of the case said that she respectfully adopted what Mr. Justice Popplewell had said in AAM about this, at paragraph, which is quoted at paragraph 97 of the tribunal judgment.
Yeah.
But if your lordships look at that, and there are 2 points I'm going to make about this. The first is there was no argument about it. The second is, as Mr. Justice Popplewell, as it was, says there, this was not a formal concession. The MasterCard's position was plainly realistic. The setting of the MIF was pursuant to an agreement between undertakings. Now, again, that's not what we're arguing about here, because the tribunal has accepted that it is at least arguable that in relation to the setting, the level of MIF, I'm not sure I understand the distinction between the two, it is at least arguable that that was a decision made by VISA Inc. alone. Now, unless there's anything I can assist your lordships with in relation to that part of the case, those were our submissions on that.
My lords, very briefly, on the respondent's notice and the cross appeal on VISA Inc. On the respondent's notice, Ms. Smith said that we were looking at the wrong market. She said that when we speak of interregional MIFs being reduced to zero, and therefore issuers not being encouraged to use Visa and cardholders switching to more expensive forms of payment, Ms. Smith said we were looking at the inter-system market between payment schemes, whereas it's the acquiring market that's relevant for our purposes in this hearing. But of course, the competition in the inter-system market produces direct effects in the acquiring market, which is why it is relevant to note, as we say in our evidence, that if the interregional MIF were cut to zero, issuers would not have the incentive to encourage cardholders to use it. And there is a risk, point for trial, that cardholders would switch to methods such as Amex, which are more expensive for merchants. And that means that even if all the other elements of the Supreme Court's essential facts, paragraph 93, are satisfied, the MSC would still be higher overall. Now, my lord said to me yesterday, well, is that really the proper focus? Because is it not just the Visa bit of the MSC? Visa can control the other elements. Of course, for these purposes, all the other inputs into the MSC, the Amex charge, the China Union Pay charge and so forth, are all assumed to be benign, to have no competition problem, which is why the courts have said in the other cases that if we take out the anti-competitive Visa MIF, the rest of the MSC can be competed for in its totality, even though the MSC would include charges from Amex and China Union Pay and the rest. They're all assumed to be benign for competitional purposes. And we say you have to look at the MSC as a whole, because the concern in that sixth fact was that the MSC overall would be higher as a result of the restriction of competition. And we say, in respect of interregional MIFs, if they are reduced to zero, that won't be the case. I move on then to the cross appeal on VI. It's important, my lords, to emphasise that my point here is not the same as Mr. Rabinus's point about the airport charges. I have a separate point to make about why the tribunal's analysis on Visa Inc. doesn't work, and it is a focus on the counterfactual. But the counterfactual cannot be delivered by these defendants. And the point I was discussing with the Chancellor, and this is my final point on paragraph 107, is that if in the counterfactual VISA Europe is told that it must have a zero MIF, a settlement at par, or if it's told no default settlement rule at all, the EU merchant or acquirer will still have to pay the interregional MIF set by VI, by VISA Inc., because there will be a bilateral agreement for the reasons given by the tribunal. And the Chinese issuer for these purposes will still insist on the full VISA Inc. MIF, and the acquirer and the merchant will have to pay it for the hold-up reasons that we discussed yesterday. And that's the vice in that this is my very last point, the vice in that last example, paragraph 107 of the tribunal's judgment. The example of the European acquirer being able to negotiate with the Chinese issuer for a lower MIF. That's what can't happen now, says the tribunal. My short and final submission is that can't happen in the counterfactual either. Because in the counterfactual, whatever VISA Europe is told to do, it makes no difference. There won't be a bilateral agreement, and the Chinese issuer will still insist on being paid the full interregional MIF set by VISA Inc. And that will happen in the counterfactual also, which is another way of identifying the flaw at the heart of the tribunal's reasoning on that point. And those are my words on my submissions on
that. My Lord, thank you. My Lord, Ms Smith's sole argument in answer to my objective necessity respondent's notice point is that the Court of Appeal held in Sainsbury's that competition from all third parties is irrelevant to the ancillary restraint argument. And I'll be saying that is not what the Court of Appeal held, and it is wrong. I'll summarise the argument first and then seek to make it good. Firstly, the Court of Appeal held that the relevant legal test for objective necessity is whether the type of main operation can survive without the restriction of the default MIF. In that case, which didn't involve any complexities of product or geographic market, the Court of Appeal held the type of main operation was a four-party card payment scheme. And that meant essentially the relevant question for objective necessity was, in the UK and Ireland, which was the bit at issue, can four-party payment card schemes generally survive without a MIF? It wasn't, as we try to argue, that whether MasterCard could survive specifically without a MIF. Both MasterCard and Visa are four-party payment card schemes, and what it meant was we couldn't justify use of a MIF by MasterCard by pointing to another materially identical, as the Court of Appeal held, four-party card payment scheme. So that was, we are both main operations in that language of exactly the same type, four-party card payment schemes. That does not, however, mean that objective necessity prevents account being taken of operations of a different type which are not the same four-party card payment schemes, such as Amex and the variety of other international ones we've talked about. Say, the aim of the objective necessity tests, I'll show you the MasterCard CJAU judgment on this, is whether the restriction is necessary for the main operation to be economically viable, is the language, which is tested by looking at the relevant scheme in its economic and legal context. I simply say you cannot test economic viability in its economic context by ignoring realities such as lawful competitors who are not operations of the same main type. And I suspect that simply must be right, because if you ignore those kind of economic realities, those kind of competitors, then objective necessity becomes completely robbed of any purpose at all. You're not testing whether something is in fact likely to happen if you're not looking at the genuine economic realities. So that summarises the argument, I'm now going to go back to the cases to make that good. It will be two cases, the Court of Appeal and then MasterCard CJEU. So starting with the Court of Appeal, Bundle 3, tab 12. And just to set the scene, the relevant section of this is going to be, it picks up at page 1017 in the numbering of the bundles. But to put this in its context, our argument, MasterCard's argument in the first wave claims, and that succeeded before Mr. Justice Popplewell, was that without a MIF, MasterCard would not be able to survive as a result of the threat of competition from VISA. And what's called the asymmetric counterfactual, the idea that you can't presume that VISA will also be at zero, and in those circumstances we would fail as a result of that competition from VISA. And that was the argument, therefore the MIF is objective necessity. Obviously we lost on that point, but that nonetheless, that succeeded before Mr. Justice Popplewell. What MasterCard did not argue was that we would not, in that context, which was a case dealing with simply UK and Irish consumer cards, a very narrow geographic and very specific product, we did not argue that we would be unable to survive due to the threat of Amex. And we didn't make that argument for factual reasons. Simply, in the consumer card market in the UK and Ireland, Amex is not a big enough player to knock us out. That doesn't simply follow that that's true everywhere else. We say it's not. Now, the Court of Appeal went on to hold, and this is at paragraph 207, that, perhaps not surprisingly, that MasterCard and Visa are, for the purposes of Article 101, materially identical. And the summary was, we are both four-party card payment schemes with an honourable cards rule for credit and debit cards, in which default MIFs are set, which are paid to issuing banks and passed on to merchants.
Sorry, I wasn't keeping up. Which paragraph are you on?
Paragraph 207. The short point is we're materially identical. Four-party schemes with an honourable cards rule and using interchange fees. So we're materially identical, which is why we're operations of the same main type. And then going back to the law and objective necessity, which is picked up at page 1017, under the heading Part 4, in the middle of the page, just above paragraph 58. This is where the Court of Appeal considered the legal issue, which was essentially, at this point, were we entitled to point to Visa as essentially materially identical, but nonetheless as a competitor, as a rationale for being allowed to charge interchange fees. And the Court of Appeal starts off at paragraph 58, setting out the law, although it's not expressly stated in Article 1011, it's well established in EU law that a provision of an agreement which has the effect of restricting competition does not constitute an infringement if it is objectively necessary for the implementation of the main operation. And the main operation became very important language here, and that was essentially where the battleground lay. Implementation of the main operation of the agreement, provided the main operation does not itself infringe Article 1011. And that was essentially the point. What is the language of main operation in the European cases? What does that mean? Paragraph 59 sets out again, which I don't disagree with, it wasn't in dispute, but the test is impossibility. And then we see at paragraph 60 essentially what the argument was, that the merchants and the commissions submitted that objective necessity is a relatively abstract exercise concerned with whether, without the restriction, a main operation of the type in question would be impossible to carry out. So what they're saying, it's about the type of operation, not about the specific operation, i.e. MasterCard, which is what we were trying to argue at the time. So that was the argument. The Court of Appeal, paragraphs 60 to about 71, went through the European law, considered that our arguments, those accepted by Mr. Justice Popplewell, were wrong. I don't need to go through that bit now. But then the conclusion at the end of paragraph 72 is the important bit. And it starts about 6 lines up from the bottom, the words, it follows.
From the bottom of what?
Paragraph 72, my lord, page 1021. And it's about 6 lines up, and it starts it follows that, the section there. So this is the conclusion as a result of analysing the case law. It says, it follows that the ancillary restriction must be essential to the survival of the type of main operation without regard to whether the particular operation in question needs the restriction to compete with other such operations. And just to analyse that for a moment, type of main operation, come to see, is four-party card payment schemes, as opposed to the particular operation, which is MasterCard. And what the Court of Appeal also says in that sentence, without regard to whether the particular operation needs the restriction to compete with other such operations. Other such there is a link back, I say, to the types of main operations of the same type. So we couldn't look at VISA, an operation of the same type, to justify MasterCard, the specific operation, being able to survive. So that's what the Court of Appeal, I say, concluded. They were excluding another operation of the same type, and then we see that said quite specifically in paragraph 74. It follows in our judgment that Popperwell J was wrong to conclude that the issue of whether in the absence of the restriction in question, here the default myth, the MasterCard scheme would survive in view of the competition from VISA. So it's making clear it's MasterCard can't rely upon VISA for that. And just so I've dealt with the point, which is the last sentence of paragraph 72, which says all questions of the effect of the absence of the restriction on the competitive position of the specific main operation. But again, that's just simply saying MasterCard itself, as opposed to operations of this type. So it's again trying to say we can't just rely on our specific individual position as a particular business. So that's what I say the Court of Appeal was looking at and held. And then we come to the paragraphs my learned friend relied upon, which is 198 to 200, starting at page 1048. That essentially is, it's headed discussion, but at that point, having made the finding that VISA was not a viable, no account should be taken of VISA, the point essentially followed. It followed because we were not saying there was anybody else for UK consumer cards that could put us out of the market. And that's, I was able to say, that's what's being recorded at 198. The Court of Appeal is going to apply the legal principles set out in Part 4, which I've just shown the Court. On that basis, Popperwell J was wrong, as the Court has already said, to conclude that the MasterCard scheme would survive in view of competition from VISA was one which could be considered under ancillary restraint doctrine. Such questions relating to the application of the so-called asymmetric counterfactual, the idea that VISA would still be free, even though we were at zero in the counterfactual, that will be a matter for exemption under 1013. So we can see there that that is focused exclusively on what we've just seen, an operation of the same type, which we can't rely upon. And I'd simply say that nothing about that paragraph assists my learned friend to say, as she does, all you do is insert Annex or China Union Pay in that paragraph. That simply doesn't follow at all, unless their operations are the same main type. And then we see 199, we agree with the merchant that if questions of the subjective necessity for the survival of the particular main operation were relevant, it would enable a failing or an inefficient business which couldn't survive without a restrictive agreement to justify it. And yes, the particular main operation there is MasterCard. And then we see 200, that the only question in relation to the potential application of the ancillary restraint doctrine in the present context, and that again is important, the Court of Appeal is looking specifically, as one would expect, at the question in front of them, is whether without the restriction of a default MIF, which is the relevant counterfactual, this type of main operation, namely a four-party card payment scheme, could survive. So again, that's making good the point. It's a four-party scheme, which is the type of main operation.
Why should that be? I mean, they make the point in 199, we don't want to assist the survival of a particular main operation that is inefficient. I mean, if four-party schemes are inefficient and three-party schemes aren't, why should one protect four-party schemes?
well, but partly because, I mean, the answer is simply that those are trying to do something different. They're trying to get a group of small banks together to do something they possibly couldn't do on their own. And it's simply, to some extent, this injects another competitor into the market by, and that's sort of going back to sort of the history of four-party schemes. Is that's how they worked. You gather together lots of small banks that had small geographic areas in order to allow them to to produce something that was a viable national originally and then international product.
My lord's question is probably better directed at me, really. I think my recollection is a lot of this all arose out of an analysis of the judgment of the CGAU in Metropole, where your clients were arguing very ambitiously that Metropole meant the precise opposite of what it clearly did mean.
I think we were actually all arguing that it was impliedly overruled by the Court of Justice because they didn't.
Case, yes,
impliedly overruled by another case just because it hadn't been
another
mentioned.
case which had in fact cited it with approval elsewhere. It was quite an ambitious argument.
I can see why you're all.
But it does all come out of that line of authority, doesn't it?
It does, my lord, and I'll show you in a moment.
Yeah.
Yes, but so that's what I say. It's simply it allows essentially another type of competitor to join the market. Simply say that nothing about what is being said in paragraph 200 is in any way saying you can't take account of lawful competition from different types of main operations. Essentially there, and the paragraph 200 deals with it in a single sentence because we weren't saying that there was anybody there who could put us out of the market. It does talk about other schemes, but again, my submission on that is simply the fact that in one particular market it can work doesn't tell you anything about what might work in a different market with different competitors. So that's what I say with respect to my learned friend. She's wrong to say any part of the Court of Appeal judgment addressed the position of a different competitor like Amex or made any ruling about it at all. On the contrary, all of the reasoning is about excluding Visa. And then just to make good what I say is the sort of the relevant test, which the court I get from the Court of Justice in MasterCard, which is now in bundle 1B, tab 5.
Yep.
And start with paragraph 93 there. And it's the second half of the paragraph that starts at the bottom of page 360, about 5 lines up. It's talking about Article 103 and how that operates. It says, it's paragraph 93, but it's over the page, my lord, page 360. About 6 lines up starts by contrast. So, as is apparent from various paragraphs of the present judgment, the objective necessity test referred to in those paragraphs concerns the question of whether, in the absence of a given restriction, a main operation and to which the restriction is secondary is likely not to be implemented or not to proceed. So that's the fundamental question you're looking at, is that if it's a lawful main operation, will it or will it not proceed, but measured by reference to what the Court of Appeal says about operations of this type. And then paragraph 94, 2 paragraphs from the General Court's judgment are cited, and we see they say at the end of it, the Court of Justice says the General Court did not err in law, so it agrees with them. It's the second of those I particularly emphasise, where it says essentially that the MIF must be regarded as being objectively necessary. So it's the third line. If it is apparent from the examination of the MasterCard system in its economic and legal context that it's still capable of functioning without it. I emphasise in its economic context, that must take account of.
And it's an objective test, and it's very high test. It's effectively a test of impossibility, isn't it? I mean, the point is that it's no answer to say, well, our scheme is, as it were, flagging if this particular restriction is removed. You have to demonstrate that the scheme simply, it would be impossible for it to operate at all.
Impossible to operate at all, but then we'll come to the next bit.
Impossible for an operation of this kind to operate.
At
So
all.
in other words, impossible for 4-party schemes to operate without a MIF.
Yes. But as we'll see, my lord, in the next paragraph, it's paragraph 111 I wanted to show the court as well. And again, it starts the second bit of the paragraph over the page at 363. It says the General Court was therefore correct in concluding that the counterfactual hypothesis put forward by the Commission could be taken into account insofar as it was realistic and enabled the MasterCard scheme to be economically viable. So, my lord is quite right to say the test is impossibility, but that is measured in a sort of commercially sensible way. You are looking about, is it commercially viable, economically viable to do it, not in some theoretical kind of, yes, you could do it, but no one will do it because it would be commercially, economically absurd. So, yes, it might be right, we could run a scheme that will have 4 customers, but that's just never going to happen. It's just not going to be cost effective to do so. But again, I take from the words economic viability that it's just impossible to see how you can have a test which is about taking account of the economic context, testing economic viability, seeing whether the scheme is likely or not to proceed, without taking account as something as important as a lawful competitor, which is not of the same type, such as
Sorry, Mr. Quinn, I lost you again. Which paragraph were you reading from there?
Well, I wasn't reading from one. That was the summary of my argument, my lord. But so the three checklists from that were, given you're told to look at the economic context, paragraph 94, that the test is whether or not the scheme would be economically viable, paragraph 111, and the test is whether or not it's likely to be implemented or not proceed, paragraph 93. I simply say you couldn't sensibly carry out any of that analysis ignoring lawful alternative competitors of a different type, such as an Amex. And that's the reason why, with respect, my learned friend, it's wrong to say you ignore all competitors of any type, and then we are simply, our evidence shows it's an arguable point, and my learned friend didn't dissent from that bit of my limb of my argument. So it would be, I'm not saying that I can in any way win objective necessity before you on the evidence, nor do the CAT think we were. It's simply, it is an arguable basis, another arguable basis for saying that in relation to inter-regional fees, they may be lawful under 1011 and therefore no summary judgment. My lords, thank you, and I'm sorry that meant you had to stay on after lunch.
No, thank you very much. Right, we've all finished then. Thank you all very much for extremely interesting, stimulating arguments.
I promised you that I would hand up copies of the order, the draft order that was sought by the tribunal, for the tribunal below. I can hand up 3 copies. You'll see there is no formal application notice. This was done in the slightly informal way that things are done in the Competition Appeal Tribunal as part of a case management conference by way of letter application. But there's a draft order attached to the letter which sets out the order sought on in paragraph 1.
Yeah, but if you read 1 and 2 together, the point is that it's only purporting to deal with 1011 and then saying, well, if it was in breach of 1011, is it exempted by 1013? So although it's not put as a declaration as such, that's essentially what it is. Well, thank you all very much for the interesting, stimulating submissions, and thank you to everybody behind you, both your juniors and your solicitors, for the presentation of the case and for eventually dividing up the authorities so I didn't have to complain about replacing a strain injury. We'll obviously reserve judgment. I'm not going to make any promises as to when judgment will be handed down, but when you get the draft judgment in the normal way, it is simply for correction of any obvious typographical errors, not for re-arguing the case. And if you can agree a draft order between you before hand down, then that would be great. If you can't, we'll deal with any issues in writing. Otherwise, a hand down will be almost certainly remote in accordance with the usual practice. Finally, I have to remind you that there will be an embargo on the draft judgment. The details of the terms of the embargo are now on the face of the draft judgment, and they have to be taken extremely seriously. Copies of the judgment only to be given to people within your teams who are involved in the consideration of whether it accurately reflects everything, and whether the court has or has not got its grammar right. It is not to be used for ulterior purposes such as preparation of chambers plaudits for the winning team. You'll be well aware there have been a few unfortunate breaches of the embargo in the recent past. So the Master of the Rolls is very keen that we should impress upon everybody the need to comply with its terms. But apart from that, those of you who are going to have some summer holiday, I hope you'll all have a very good summer.
Bye.